Good morning, dear members and friends. Welcome and thank you everyone who is joining us today for this webinar that we have prepared in cooperation with HENGELER MUELLER and our partner from WOBESER y Sierra. There is an increasing legislative trend toward holding companies accountable for their own ESG practices as well as those of business partners within their supply chain. Many companies will already conduct due diligence relevant to ESG issues in respect of their business relationships and supply chains in accordance with international principles and standards. The topic of today's session, ESG Focus, Impact of German Supply Chain Regulations in Mexico, Are You Prepared?, is relevant for both German and international companies in preparation of the corporate due diligence law, which will enter into force next year. European companies and their suppliers will be obligated by law to observe human rights and environmental due diligence obligations along the supply chain appropriately. Now, I hand over the microphone to Rupert Hüttler, who is the moderator of the session. Thank you very much.
Thank you. Thank you, Indira. Hello, good morning. Thank you for joining us today. Thank you to Johannes Hauser, Andreas Müller, CAMEXA Managing Director and Subdirector, who unfortunately are not able to join us today. But thanks also to the whole CAMEXA team for helping us to organize this webinar and giving us the opportunity to talk to you a little bit about this trendy topic. As Indira said, you probably have heard about ESG. ESG is a process for managing material risks and for identifying opportunities related to environmental, social, and governance matters. Until recently, ESG was perceived as a niche, but it's quickly becoming mainstream around the world. The adoption of an ESG approach is a global, unstoppable, and irreversible trend. Sooner rather than later, companies that ignore ESG will have difficulties raising capital, attracting talent, and engaging consumers. So you have heard about ESG, but have you heard about the Lieferketten-Sorgfaltspflichtengesetz, the new German law on due diligence in supply chain? Don't worry, you don't need to pronounce it, but you should be aware of and prepared for a set of new supply chain regulations which might have an impact on your business. These new supply chain regulations will have an impact on Mexican subsidiaries of German companies and on Mexican companies which are part of an international supply chain of German corporations. Within the next 40-45 minutes, we will give you a little bit more insight on the latest developments on ESG matters in Europe, especially in Germany, and obviously in Mexico. And we will talk about the efforts businesses in Germany and around the world will need to undergo in order to achieve compliance with the new due diligence regulations of the German Supply Chain Act. We know that legal terminology is not always easy to follow, so we will try to explain the subject by making reference to some practical cases we have handled in recent times. At the end of our presentation, you will have the opportunity to ask some questions. Please post them in the Q&A section of the platform. You will find it below your screen. But before we dig into the subject itself, I'd like briefly to introduce my colleagues. It's a great honor for me to share the stage with two distinguished colleagues of one of the best and most well-known German law firms, HENGELER MUELLER, which you probably all know. HENGELER MUELLER has a long history of successfully assisting and advising clients in complex transactions in different practice areas, among others in ESG-related matters. On one hand, we have Dr. Daniel Weiß. Daniel is partner of HENGELER MUELLER based in Frankfurt, Germany. He advises predominantly corporate clients on internal investigations, compliance, governmental investigations, restructuring, and crisis management. Daniel has a broader experience in advising clients on complex multi-jurisdictional matters comprising investigations, litigation, criminal proceedings, and stakeholder management across various jurisdictions in the European Union, Asia, and the Americas. Recent matters he handled include advising a global conglomerate on accounting fraud matters involving entities in Japan, the EU, Hong Kong, and China. He advised Robert Bosch in the diesel emissions matter, as well as investigations into alleged tax fraud schemes in Europe known as CAMEXA. Moreover, he advises TÜV Süd in relation to the rupture of a tailings dam in Brumadinho, Brazil, and a financial institution. Daniel holds a PhD degree from the University of Tübingen, as well as an LLM from the University of Chicago Law School. Welcome, Daniel.
Thank you very much, Rupert.
Philipp Ersfeld is a senior associate of HENGELER Müller based in Frankfurt, Germany. He advises inter alia corporate clients and financial investors on a broad range of corporate matters, corporate reorganizations, and M&A transactions, often in multi-jurisdictional matters. Philipp studied in Germany, Spain, and the United States, holds an LLM from the University of Pennsylvania Law School, and has previously worked in Mexico City. Pablo Jiménez. On the other hand, allow me to introduce my partner, Pablo Jiménez, who co-leads von WOBESER's corporate and M&A practice and coordinates our firm's ESG practice group. Prior to joining von WOBESER recently, Pablo was the global vice president of reputation and communications at the world's leading brewer, Anheuser-Busch InBev. His previous position at AB InBev was vice president of legal and corporate affairs for the Middle Americas region. Prior to joining AB InBev, Pablo was director of legal and institutional relations for Cinépolis. Previously, he was an associate in a major law firm in Mexico City and a visiting attorney at Sullivan & Cromwell in New York. Pablo holds a law degree from Escuela Libre de Derecho and a master's degree in law from Stanford Law School. He has studied studies in finance, corporate reputation, management, and sustainability, including a certificate in ESG and sustainable capitalism from UC Berkeley Law. Last but not least, my name is Rupert Hüttler. I'm a partner of our firm von WOBESER Sierra. I joined von WOBESER around 23 years ago when I moved from my home country, Austria, to Mexico. I'm a member of our firm's corporate and M&A practice group. I'm holding law degrees from University of Vienna and the Universidad Nacional Autónoma de México. Among the members of CAMEXA, many of you probably know me since I'm heading our firm's German desk, and I had the opportunity to advise several German companies with their projects in Mexico. But enough of introductions. Let us dig into the subject. Daniel, Philipp, let us start having a look at compliance matters in the supply chain in Europe and Germany. The floor is yours.
Yeah, thank you very much, Rupert, for this kind introduction. And hello, everyone, also from our end. Very glad to be here and speaking to you. Without further ado, let's get into the topic finally, and maybe start with our first slide, which I will briefly introduce to you. We have a lot of regulation and court decisions already in this field of ESG generally, and maybe we should start with slide 2, please. I think that is a good starting point to give you a very brief overview what we already have, and then maybe turn to what is new in respect of the Lieferketten-Sorgfaltspflichtengesetz. I will only pronounce this word once, so sort of to amuse everyone here on this meeting. And with that, I would like to turn over to you, Philipp, to briefly outline to us on slide 2 the general framework of ESG as we have it currently from a European and German perspective.
Thank you very much, Daniel, Rupert, for the kind introduction, for having us. Just checking, is everybody seeing slide 2? Because I'm currently seeing slide 5, just to be sure that we are all looking at the same page.
I'm seeing slide 5 as well. Oscar, can you go back to slide 2, please?
Yeah, perfect.
Thank you.
So let's dig in. So by just giving a few examples, this first slide of our presentation shall give an impression of the impact and the visible footprint of environmental social governance topics in the EU. So first example would be the Corporate Sustainability Reporting Directive. Maybe as a background, currently EU law requires certain large companies to disclose information on the way they operate and manage social and environmental challenges. This helps, for example, investors, consumers, and other stakeholders to evaluate the non-financial performance of large companies. And the plan with the CSR directive is now to extend the scope of these reporting obligations from large companies, which is mostly public interest companies with more than 500 employees, listed companies, banks, also to smaller enterprises and to large non-capital market oriented companies. And also mandatory audit is planned. Another example would be the current multi-year financial framework, or also the current EU long-term budget for the years between 2021 and 2027, that provides for at least 25% of the budget for climate protection projects. There are several subsidies for companies that are engaging in areas like climate protection, resource saving technologies, and so on, granted by the European Investment Fund, European Investment Bank, and so on. And another example, the Next Generation EU, which is some sort of recovery plan designed to boost the recovery post-COVID, which also provides for at least 37% of the funds actually for the promotion of ecological sustainability. Whistleblower Directive is another example, which is not focused entirely on human rights or environmental law aspects, but also aims to better protect process reporting on breaches of law, of union law in general. There are in the financial sector several reporting obligations, for example, with respect to ESG aspects. European Central Bank is actually also considering now climate risks in its stress tests. Probably everyone has already heard of EU green bonds. Actually just read yesterday, Rupert, that Austria is now actually also planning on issuing a green bond. So just a few examples so that you get an idea of the footprint that ESG topics in general actually have already in Europe in different segments. And would now like to pass on to Daniel, who will introduce you to a few very interesting cases.
Yes, thanks, Philipp. Moving on to the next slide, please, Oscar. Thank you. There you see two cases which we wanted to very briefly only describe to you to give you a bit of a flavor on how this topic of ESG and maybe human rights more specifically has already entered the legal sphere. Maybe not noticed by everyone, but lawyers certainly have sensed this now for quite some time. And it has become actually quite a well-known topic in this area. So just to give you a little bit of a flavor of what is currently going on in Europe, in European courts, with, for example, a case which has been brought by a farmer from Latin America, Peru, who has sued a German power supplier on the grounds that due to its CO2 emissions, the glaciers near the farmer's hut would be melting and would be damaged, and the German company should pay for his damages. And that would, maybe a couple of years ago would have been a bit of an amusement for lawyers, but actually German courts have taken this quite seriously in the sense that they even have found in this case that in principle the farmer has a right to sue, and now it's about taking evidence what is actually going on the ground. And the judges have taken a nice trip to Peru in order to check on the ground how the glacier is actually doing, and we'll see how this case will go on. The other case we brought with us here for you today is maybe slightly less humorous. It's actually and still on the slide we're actually looking at, Oscar, just one back, please. Pakistani workers who unfortunately got injured and some even killed by a fire. And this was a case which was brought from Pakistani people in a German court against the German country. So again, crossing a long way to go to the German courts. And there the case was dismissed, but mainly on the ground that the statute of limitation had already kicked in under Pakistani law. Moving to the next slide, please. Thank you. There we have collected two cases from UK courts. So it's not only a trend in Germany, but also in other European countries. It's a case about subsidiaries who have allegedly done something wrong somewhere in the world, very far away from Europe, and the mother company in the UK actually gets sued. So there we see a trend actually that some misconduct or alleged misconducts happening anywhere in the world with maybe a tiny subsidiary somewhere, maybe not very well capitalized, will lead to claims being brought in Europe against the mother company for alleged lack of oversight, and thereby claiming that some kind of obligation was also being created thereby towards third parties, which are totally unrelated to the legal entity in Europe. And it very much relates to the degree of influence which has been exercised out of the European company to the local subsidiary. So if there's a high degree of influence, doesn't even have to be control. This can trigger under these legal theories, under UK law, actually a liability, which I think shows a very interesting conclusion that the mindset of the lawyers has changed in the world, very much more open to ESG topics, human rights topics, recognizing legal claims in this field. There is a trend to bring human rights violations from the places where people are being harmed to where the money is, the pockets reside, some in Europe, but perhaps also in other countries. Piercing of the corporate veil, as the lawyers call it, i.e. disregarding the fact that these legal entities are actually separate, mother company, subsidiary, and should only be liable for their own obligations and their own liabilities and duties, can be overcome, meaning that this mother company can be liable for subsidiaries' wrongdoing in those cases much more easily where human rights violations are being concerned. And with that outlook on the court cases, I'd like to hand over back to you, Philipp, to give us a little bit of an overview how the, now specifically coming to our topic, supply chain legislation has evolved in Europe to date. Next slide, please.
Yeah. So moving then specifically to supply chain acts and developments, kind of a couple of years ago, several initiatives were started within Europe. And here, before moving towards the German Lieferketten-Sorgfaltspflichtengesetz, German Due Diligence Act, we have pictured a few examples for alternative other European initiatives. If I'm not mistaken, first and most elaborate regulatory regime in this regard in general was established in France, and have included here a couple of key figures in this context. So French companies with at least 5,000 employees in France or 10,000 employees worldwide were covered by the scope of this Supply Chain Act, and certain due diligence obligations were established in the French Supply Chain Act, also civil liability. But so far, it seems that not too many legal actions have been brought based on the French Due Diligence Act, which might be because liability under the French regime seems to be mostly limited to very severe human rights violations. And other examples would be the Due Diligence Act from the Netherlands, United Kingdom Modern Slavery Act, which has slightly different focus, and also the Swiss that have introduced Due Diligence Act in this sphere. And I think this as a brief overview before we start, after handing over to Pablo, we will dig in deeper into the German legislation.
Thank you, Philipp. Thank you, Daniel, for sharing these insights and interesting information of these cases. It seems to me that definitely Europe, and especially Germany, is a step ahead of Mexico and takes ESG very, very serious. It's also very interesting to see that several European countries are already setting up a robust legal framework, in order to protect human rights and environmental protection standards in the supply chains, not only locally, but also around the world on a global level. This leads me to the next part of the presentation. How is the situation in Mexico? What does the legal framework for ESG matters look like in Mexico? Has the ESG revolution already started in Mexico? Pablo?
Thank you, Rupert, and thank you everyone for joining us today. So I would like to zoom out for a second from the conversation specifically on supply chain and provide the audience a quick overview on the way we see ESG and its legal implications moving in Mexico. So first, I would start by saying that Mexican companies are slowly but steadily taking part of the ESG revolution. Of course, there are noteworthy exceptions of companies, mostly public companies that are just really fastening the pace in setting the standard in Mexico. But the reality is that the law remains underdeveloped when we compare it to other countries, especially to European countries that we were just hearing about. There is today no comprehensive, consolidated, or updated framework regulation, and the reality is that judicial precedents are also very few. The most relevant provisions regarding environmental, social, and governance risks and obligations are scattered in the Mexican legal regime. They go from the Mexico's federal constitution, which provides the framework of human rights, to multiple environmental, labor, and corporate, and even administrative laws. In Mexico, currently, disclosure obligations are minimal regarding ESG matters, and for the most part, they only apply to listed companies. That does not mean that Mexico has not been part of the conversation, and proof of that is that Senator Germán Martínez from the ruling party Morena filed a bill of law last October 2020 with a comprehensive framework on corporate responsibility and due diligence. But the reality is that this bill has had no movement in federal Congress since then. We should note the very significant efforts from the private sector in advancing the ESG agenda. And I would mention specifically the Mexican stock exchanges, Bolsa Mexicana de Valores and BIVA, Bolsa Institucional de Valores, as well as the Green Finance Advisory Council, Consejo Consultivo de Finanzas Verdes. Just a couple of pointers. In 2017, the Bolsa Mexicana de Valores launched the Sustainability Disclosure Guide, which is voluntary, but has been adopted by many companies disclosing in such exchange. In 2020, it launched an index that tracks the stock of Mexican companies, of sustainable companies. And very importantly, the data shows that bonds issuances in Mexico, either green bonds, sustainability-linked bonds, social bonds, and the like, have grown significantly in the past couple of years. For example, from 2020 to 2021, the growth was 2.7 times. So the pace is really catching up. Today, since most of the focus has been on the E element, meaning environmental, we see more and more that the social component and the governance component are getting more attention. We have seen around the world the increased attention to matters such as diversity and inclusion, gender equality, but as well as the fight against corruption, anti-money laundering, tax transparency, and other matters connected to governance. So change is happening. Of course, change supported by public policy would make the transition faster and deeper. But the reality is that market forces and global players are driving the transition already. So this is the overview from Mexico, but let's go to the next slide to try to talk a little bit about ESG movement. So we all know that ESG is fundamentally a risk management tool for environmental, social, and governance risks, but it also helps us identify opportunities, because we know that those companies that can understand change coming on the climate front, of course, but also with respect to demographics, with respect to regulatory changes, are able to really grasp opportunities faster and better than other companies. The ESG revolution, as we call it, it resembles the compliance phenomena that we saw 10 or 15 years ago in Mexico. And that's why we call it compliance 2.0. As they share several features, they require, both disciplines require risk mapping, they require cross-cutting work. That means really touching upon every single part of the company or the organization. They require the existence of policies, procedures, monitoring, reporting, disclosure. Nonetheless, ESG by definition has a wider scope and it's moving faster than compliance did 10 or 15 years ago. You may remember that 15 years ago, there were very few Mexican companies that had really robust anti-corruption systems, let's call them. And mostly those were companies that were either subsidiaries of multinational or international companies and listed companies. Whereas today, irrespective of the size and whether or not you're a public company or a multinational, you are expected to have a very robust anti-corruption system and fully working. So the same thing is happening with ESG, but this is happening faster. For example, if we talk about the biggest Latin American countries, so zooming out for a second from Mexico, we have as a firm been looking at the disclosure of the largest, let's say the 50 largest Latin American companies that have cross-jurisdictional operations. In 2015, it was around 50% of those companies that mentioned ESG in their disclosure documents. Whereas today, in 2021, 100% of those companies actually touch upon ESG initiatives, who is responsible in their company, what are the policies that they have adopted, of course, in different level of detail. But the adoption is quite quicker. The multiplicity of areas that ESG touches upon and the multiple inputs that it requires demands internal coordination. So that means, let's call it a control tower or an ESG lead that brings together and coordinates all the efforts and has the visibility and prepares the reports for management to oversee ESG initiatives. And let's not forget the board of directors, as the ultimately responsible for risk management, should be overseeing ESG in a company. This is very important. Who should be, we receive this question frequently, so who should be in charge of this ESG coordination, or who should act, which function should act as the control tower or ESG lead? The reality is that there's no one-size-fits-all recommendation on who should be responsible or which function. It really depends on your industry, the jurisdiction where you operate, the markets where you operate, your business model, whether or not you're a regulated company, how mature are your different functions that can take upon this big responsibility. But the landscape in Latin America is that around 50% of the large companies have entrusted this function historically to the sustainability function. So sustainability evolves into a broader mandate, which is ESG. 25% or 1/4 entrust this function to corporate affairs and public policy teams within a company. And the rest, the remaining 25%, entrusted to legal and the compliance functions, and some of them also to the communications department. What we're seeing more and more is that legal functions are taking greater and more significant roles in this process. And why is that expected? Because good governance is the foundation of any solid ESG program, and we're getting into an era where greenwashing or vacuum claims are no longer admissible, and they do have consequences. So having a very strong governance procedure, processes overseen by your legal and compliance function is critically important. So companies in Mexico are increasingly seeking legal advice in several matters. Let's group them in this four: corporate governance and risk management, environmental and climate action. How is that they would be able to deliver under under environmental commitments? How is that they comply with the law and regulations, international standards, and voluntary commitments? How is that they tap into sustainable finance? We have briefly talked about sustainable bonds, sustainability-linked credit facilities, and so on. And how is that your business understands, protects, and according to the UN framework, protects, respects, and remedies potential violations on human rights. Last but not least, as Mexican companies and as Mexican legal advisors, we have to make sure that we understand this trend that our friends from HENGELER were talking about, that legal risk expands beyond your four walls. So doing the right thing within your operations is no longer what is required. You should be mindful about the responsibility and the potential liability that you have with respect to your value chain. That means, of course, your subsidiaries, but also your suppliers. So this trend is something that we should be talking about more and more, and that's, of course, the main topic of our conversation. So with this, I turn it back to Rupert for our colleagues in HENGELER to continue on a deep dive on the German Due Diligence Act. Thank you.
Thank you, Pablo. Would you agree that there's a huge field of opportunity for companies out there to gain certain leverage over their competitors, no, with all these ESG matters, no, in complying all these ESG matters? Let us jump back to Germany. The new German law on due diligence in supply chain. What is the background, scope of application, the main content? Daniel, Philipp, do you want to elaborate?
Sure. Thank you very much, Rupert. Oscar, could you please move one slide forward? That would be great. Slide 6. Perfect. Thank you very much. So after having discussed ESG in general and inter alia examples on due diligence acts, ESG in Mexico, and Mexico on the move, we can now turn our attention to the German Due Diligence Act with this remarkable name, Lieferketten-Sorgfaltspflichtengesetz. And in the next two slides of our presentation, we've just briefly outlined some information on the background, the procedural status of the Due Diligence Act, but in the interest of time and also the wakefulness of the audience, the plan would not be to discuss in detail every of these steps. I think what is important also in general, and that's illustrated in these 2 pages, rather cumbersome process, rather long process to achieve this act. There was controversial debate, and this was shaped as a starting point, one might say, by the United Nations Guiding Principles on Business and Human Rights of 2011. Based on these, the coalition agreement in 2013 provided actually for its implementation in Germany. But at first, the plan was actually to implement the UN Guiding Principles premised on the voluntary commitment of companies. And during the time, it has been monitored. The involvement and representative surveys have been prepared, and legislator obtained the impression that most of the companies rather did not meet the requirements of the UN guiding principles, and that therefore legislative action would actually be required. And that led to the Due Diligence Act, which was then finally signed into law and published in the Federal Law Gazette in July 2021. It comes into force in 2023, so it is not in force yet. But of course, it's not too much time left till 2023, which is why many companies, many of our clients, of course, very focused on this aspect to get ready and to be prepared for the changes and the obligations, due diligence obligations that are waiting. So when it comes to the scope of application, in particular, 3 criteria are relevant, come into mind. It's first the size of the company. And here the legislator has chosen a, let's call it, staggered approach. So at first, in 2023, it will be relevant for companies with at least 3,000 employees in Germany. But already in 2024, so just 1 year afterwards, the threshold will be lowered to at least 1,000 employees in Germany. Then, of course, in practice, it's always a relevant question, who do I count? And in that sense, the legislator specifies that, for example, employees that are posted abroad have to be counted, also temporary workers employed for a period of at least 6 months, also employees of group companies within affiliated companies in Germany. In any case, it's important that strong ties with Germany are in place, which means you need head office in Germany, the principal place of business, administrative headquarters, also a branch in Germany. But it's not sufficient that you just have some business activities in Germany. But there are no restrictions on the legal form. So any German, also foreign legal firms are actually covered by the scope of the Due Diligence Act. Then there's certain key points. I think, Oscar, if you could move to... Perfect, thank you very much. So as mentioned before, Due Diligence Act is based on the UN guiding principles. And in principle, it includes a duty to endeavor, but not to succeed, which means the company must be able to demonstrate that due diligence obligations have been fulfilled, but in general not guarantee there are no violations in their supply chain. And corporate due diligence obligations, that's of course a very, very important and very relevant aspect since there are few. And these are things that many companies have already started working on, currently in the process, or at least thinking about starting to kick off this process. So the obligations include, for example, the establishment of a risk management system. Designation also of responsible persons. It's very important to have internal responsibility for this topic. That might be, for example, by appointing a human rights officer, but not necessarily. So there are no kind of concrete requirements how this has to happen. In any case, senior management needs to seek information on a regular basis about the work of this responsible person and needs to be informed. It's important to conduct also regular risk analysis with respect to risks related to human rights violations or environmental violations. Such a risk analysis has to be conducted at least once per year, but also ad hoc. If something changes, for example, you might launch a new product and know this new product launchment involves certain risks that you didn't have before. So always if you have indication, then a TOC risk analysis would also be required. Another aspect, a requirement is to issue a policy statement on the human rights strategy. Take preventive measures if you have identified any risks. This can be general development, implementation of certain processes and strategies, can be training of employees, for example. This can also be very careful supplier selection and ask for contractual assurances from direct suppliers, or to establish contractual control mechanisms, for example. Corrective measures or remedial actions might also be required if you're facing a violation or encounter a risk. You have to establish a complaints procedure with enabling persons to report human rights or environment-related risks or violations. And there's also documentation and a reporting requirement in this regard. Then one of the key words that is used very frequently in the Due Diligence Act, the principle of appropriateness. So your risk management system, measures you take, they have to be appropriate, which is first, of course, rather vague. So it needs to be interpreted at the end in each individual case. And there are certain factors that need to be considered. So, of course, the type and the scope of business you are in. Another important aspect, the ability you actually have to influence the party, supplier, for example, that is directly responsible for risks to or the violation of human rights or the environment. It's also an important aspect, how severe the violation would typically be, or if the violation is reversible, how likely the occurrence is, and if you have also contributed actually to this risk. So these are factors, among others, that have to be considered when actually determining if your measures for risk management are appropriate. So in plain, one could say the greater the influence the company can exert, the more probable and severe the expected infringement of the protected legal position, and also the greater the contribution of the company to this cause, the greater would also be the effort a company can be expected to make to avoid or end such an infringement. The Act also provides for penalties. These can be financial penalties, administrative fines, then also the exclusion from bidding for public contracts, or well, the mere fact of being monitored by a federal agency. And liability is another aspect that was in the making of the law heavily debated. Heavily debated was the question if this new Due Diligence Act would actually also be a connection point for civil liability. And in the course of the discussions, the legislator decided here to state expressly that a violation of the obligations under this act does not give rise to any liability under civil law. It does not mean, and that's also specifies, that liability under civil law arising independently of the act would be affected in any kind, but it would not be the act that actually gives rise to the liability under civil law itself. And I think then at the end, we just wanted to provide you with a quick view on the plans at the European level. Thank you very much, Oscar. Because of course, in Germany, within the European Union, you're always to a certain degree dependent on what happens at the European Union level. And there has been a proposal also for a directive on corporate sustainability due diligence. This has been published and is currently discussed in the European Parliament. In general, a quite controversial debate be expected. For example, because even though we have a Due Diligence Act in Germany and in certain other countries in Europe, there are still several member states that don't. And therefore, there will definitely be some discussion involved in the next future. But that's something that could then in the future also potentially change requirements set out as of now in the German Due Diligence Act. So the legislator already mentioned that if kind of notable differences were there, they would adjust also to avoid competitive disadvantages of German companies in the European context, for example. And in any case, national law would have to follow the lead of European law if it contains stricter requirements at the end. Okay.
Let me put this a bit into perspective, Philipp, if I may. So this is all, of course, technically very interesting. And I guess this gives rise a bit to the question, does it really matter? And I think it does, because the fines which are imposed by the German law could actually be as high as 2% of annual turnover of the entire group. So it's really a tough sanction, apart from the blacklisting and all the other points which Philipp mentioned. And I think it will really change the way people do business quite significantly. And we already see this happening. Of course, it's a gigantic task. So if you look at a large company which has maybe a couple of thousand suppliers, which again have a couple of thousand suppliers, I mean, you can have an almost infinite number of suppliers to verify until you actually get to the source where someone is digging something out of the ground in terms of natural resources, until you get the end product of your immediate supplier. So that is really a challenge. And the liability point on top of that, which Philipp now mentioned, is a real concern. So given the court cases, which I explained to you already, which we already have today without a supply chain act in place, now given that we will have the supply chain act in the future, even though that it does not stipulate a specific liability provision, as Philipp pointed out, it will certainly shape the way people think about the law as it currently stands. And if the EU plans come into play as we see them today, maybe in, I don't know, 5 years or so, will lead to legislation, it's not unlikely that there will actually be additional liability risks specifically attaching to violations of this law. So it is something which I think European companies are very closely following, and also I think a topic which will impact the way they will be doing business group-wide in all countries and markets they are active in.
Mm-hmm. Thank you, Daniel. Thank you, Philipp. Very interesting. We heard a lot about the German law, and most of you are members of the CAMEXA and involved in Mexican businesses, which are somehow related to Germany. And I guess your question will be, how does this affect me here in Mexico? And let me allow me to try to break this down a little bit for you with three questions and two cases we have had recently already here in Mexico. No? I think, Oscar, if you can go to the next slide, please. I think from my perspective, the first question is who in Mexico will be affected by this German law? No? And there are primarily two groups of companies which will have to have definitely a closer look into that, into these new regulations. On one side, the Mexican subsidiaries of German companies, and on the other side, Mexican companies which are part of the supply chain of a German customer at the end. No? The subsidiaries, normally they will feel already, a lot of them already feel the pressure they get from the headquarter, because the headquarter wants them to implement changes to the existing compliance and governance systems, establish new ones, etc. They know exactly what Daniel just said. There will be a big pressure in Germany, because the fines can be very high. Obviously, these fines will be directed to the German headquarter, not to the Mexican subsidiary, but obviously they want to comply in the whole supply chain. So that's, I think, one group is the Mexican subsidiaries. On the other side, we have any Mexican company who is part of a supply chain of a German customer. And as I said, the German authority has no faculty to impose a fine on a Mexican company. No, but it will lead to a German company as yes, and it will lead to the situation that German companies will carefully select their suppliers. They will carry out a due diligence. They will maybe not pass on business to suppliers in Mexico which are not compliant or which for them they consider them a certain risk. So you might lose at the end. You might lose business with your German clients or German customers if you're not preparing for this regulation. No. So from my perspective, I think it's now the best moment, even though the law is still not in effect. As we heard, it will be effective as of January 2023. But it takes a long time. So if you haven't done anything, I would suggest to get involved in this issue. For me, the second question, if I see it from the Mexican perspective, is if I look at the situation of human rights and supply chain in Mexico, there are certain risk areas which might be problematic. Obviously, there are certain also industries which might be red flags. No, risks area which might be problematic. If you have a look at the supply chain law itself, it establishes that companies must take measures to prevent, minimize, and remedy any identified impact on human rights and environment. That's what the law says. No? And it's established a canon of human rights risks. And I have mentioned here some of them. Child labor, for example. We know child labor in Mexico is not as a big issue as maybe in other regions of the world, but there are certain industries, let me mention agricultural and mining industry, where we have heard that there are some cases and might be some cases. So if you're in this industry, you will probably look into that a little bit more. Occupational health, definitely an area where you have to look at. We had recently a litigation matter actually with a client. There was a claim because from workers from a production facility because they claimed that the earplugs were not effective. No, so this is getting more common in Mexico, and definitely an area where in your risk analysis you will have a look at. Freedom of association. You all know there was a huge amendments to the labor law recently and to the international treaties such as USMCA. And I think there's a lot going on. The situation is getting better, but in certain industries, I think, and probably most of you have heard about the GM case with the negotiations with the new union. Very complicated, but they're moving towards definitely the freedom of association, but in certain companies there's still not this freedom of association is still not guaranteed. So this is a typical risk area which I would look closer into. We have discrimination. This is also a very broad area, and in this area, it's interesting. We have seen a lot of public commitments of companies stating that they are committed with this risk and try to do everything to avoid this risk and minimize these risks. But in practice, it might look a little different. And maybe a general comment here: you have to apply local Mexican standards whenever you look into these risks. No, obviously, I guess the German authority would be very happy if it would apply German standards all over the world, but this is obviously not possible. No, but if your company has committed to stricter standards by publishing on the homepage statement, a commitment with regards to diversity, for example, you will be held. You will have to. It will be measured with this higher standard you committed yourself to. So this is another area where you probably have to look into. And we have environmental concerns. This is very important in Mexico. The Supply Chain Act established, for example, 2 risks, which I just want to mention so that you have an idea what we have to look into. On one side, it says that the excessive water consumption that deprives a person of access to safe drinking water is considered a violation of human rights. that's pretty strict. If you imagine a Mexican production plant, and you have a community besides, and the production plant consumes too much water, which maybe is not necessary, this could be a violation of human rights. So if you're a German subsidiary and you look into your suppliers, you really have to go into detail with your suppliers. Another risk which is expressly mentioned in the law is the water pollution that potentially damages a person's health as well. This is exactly the same. I know that there are laws in Mexico in place and they should be fulfilled, but in a usual due diligence, you probably don't look into that much detail. So the other question would be which industries, which sectors might be considered red flags. Obviously, it depends on the particular case, no? But if you have to point an industry out, from my point of view, it would be definitely the agricultural industry, the mining industry, maybe to a lesser extent, the chemical industry due to the specific typical environmental concerns. No? But as I mentioned, I think you should, it depends on your business and you should look into all of your suppliers. Let's go to the next slide, please, Oscar. Let me try to explain the possible practical implications with two examples we have had recently. Okay, the first is we have a client, a large corporation, we headquartered in Germany, and they are incorporating the Supply Chain Act's canon in the existing compliance and governance system. No? The Mexican subsidiary obviously was surprised. They were not prepared for that, and they were asked to review and comment, considering local circumstances, challenges, and to prepare the implementation. So they turned to us and asked for help. And at the end, what we did is we helped them with all the steps mentioned in the supply chain law. The first is set up a local risk management. Pablo talked about that. Daniel talked about it. Philipp. You have to allocate responsibilities, define resources, HR, money, who will be responsible. You will maybe appoint a human rights officer. So you depends obviously on the size of your business in Mexico and the organization you have. No, you will have to carry out a local risk analysis. As I said before, look into your supply chain. No, identify and prioritize risks. No, and obviously you have to communicate the result. Input on a policy statement. We were asked to give our input. There is a required policy statement which has to consider the specific local risk. And we assessed on the local preventive measures as well. No? There you have to separate there are certain preventive measures you have to take in your own business and in your supplier's business. Okay, if something happens, if there is a violation, you will need to act and you will need to prepare to do so, because when it happens, you probably have not the time to set everything up. No? And finally, we commented on the remedial measures, complaints procedure. The complaints procedure is also very interesting because you have to give access to people outside your organization. You need to publish that, think about hotlines, web pages, etc. You need to set up a procedure internally. Who will receive a complaint? What will happen with the complaint? Which time frame I have to answer, etc. How will guarantee impartiality? So all this setup takes a lot of time, involves a lot of people. And therefore, if you haven't started with that, and if you're a German subsidiary of a Mexican company, or if you're in the supply chain of a German customer, think about that, be prepared. It will help you to maintain your client and to surprise your client. Obviously, you will be a German company will select you much easier. You will have a big plus in the next pitch you present. Let's go to the next slide, please, Oscar. Another practical example which we had here in our office some days ago, a supply agreement. There was a Mexican supplier. Our client is the German customer, and he asked us to the supply agreement itself was drafted according to German law and drafted by our German colleagues, but obviously you have to take into consideration certain local practices. No? As you know, the Supply Chain Act is still not effective, but in this case, the German company wanted to renegotiate the supply agreement already, because it's a long-term supply agreement, and they know that they will be affected as of January 23. What we did is, what was different, or what was established in the new agreement compared to the old one, new obligations for the supplier, referring to code of conduct, reporting, auditing, monitoring, education, training. It also includes a section of sanctions, contractual penalties, for example, up to suspension of the commercial relationship, and as a last remedy, the possible termination of the supply agreement. No? We had a so-called pass-on clause in this agreement, which means that at the end the supplier has to establish or enforce the code of conduct, and also vis-a-vis its own suppliers. No, I understand that this is controversial in Germany. According to German law, if this is in line with German law, we established it in this particular supply agreement as a best effort clause in order to avoid any further discussions. No. So as you see, there are already a lot of companies in Mexico which are concerned about this law and the implications this might have in the future in Mexico, and they're already taking certain actions. So if you haven't started, I think now it's a very good moment to start. And with this, I think we are coming to the end of our presentation. I hope the information was useful to you and your businesses. Before concluding, I want to give Daniel, Philipp, Pablo the possibility to make maybe a final closing statement. I don't know who wants to start.
Yeah, maybe I can briefly summarize my thoughts, which came to my mind when I now heard all this, also from very interesting comments here from our Mexican friends. I think this is a topic which I think is very relevant. It's embedded into the general ESG development, which is mission critical now for many companies, and I believe it is a topic already and will be even more so in the future, with relevance for senior management and decision makers and thought leaders. So very glad we were able to have this session with you today, and of course looking forward to possible questions from your end.
Pablo, let's continue with you.
Two very quick ideas. The first one is that managing with an ESG perspective is no longer a fad, but a necessity. So if you're not doing it, don't sleep at the wheel, because it requires or it will entail market consequences and also legal consequences. And the second idea is that the era of when you only mind of your own house, meaning your four walls of your business, is no longer acceptable. You have to be very mindful about your environment and the legal consequences it may bring. Thank you.
Thank you, Pablo. Philipp?
Well, thank you very much. And thank you for listening. I hope as well that was very helpful for you. And following up on Daniel and Pablo, I would also second it's, I think, a very interesting, a very relevant topic that is embedded in so many different legal areas. So cross-disciplinary relevance, you encounter it from a legal practice perspective very, very frequently in different contexts. And it is a very dynamic area, so it's important to stay tuned.
Yeah, thank you, Philipp. I would conclude with referring to the title of our webinar. We ask you, are you and your company prepared? So after having heard all this information, the practical cases, what we have seen until now, I would like to repeat the question: do you really feel that you are prepared and you and your company are prepared? If not, please feel free to contact my colleagues, Daniel, Philipp at HENGELER in Germany, Pablo, myself at von WOBESER, and obviously the whole von WOBESER team. Here, you will see here our contact information. We already, I think, the time limit, but let's jump quickly to 1-2 questions. If you have any further questions afterwards, please feel free to send them to myself, and I will canalize them and talk with my colleagues about them and give you an answer. Maybe the first question I saw in the Q&A application must be from a fellow lawyer. It says, I see ESG as an evolution of the sustainability agenda of my company. What is the role of lawyers in this process? Maybe this is for Pablo.
Very happy to take this one, and I will try to be very succinct. So I would summarize the type of work of a lawyer in 4 main fields. The first one being advisory work, the second one being transactional, the third one would be supporting with investigations and government engagement. And the fourth one may be dispute resolution. So what each of these categories entail? The first one, advisory work, means basically working with your board of directors and with your management to help them fulfill their obligations, to identify and to prioritize the critical obligations of a company with respect to ESG, prepare the reports and the public disclosure, carry out due diligence, draft policies that you would use with your suppliers. So that's, let's say, the day-to-day advisory work. On the transactional front, means basically lawyers looking at or getting involved into the structuring, the negotiation, and the execution of contracts to make sure that in transactions, namely M&A, but also loans, but also placement of bonds, the issues are correctly spotted. So if you're going, for example, to acquire a target company, you mentioned that, Rupert, that may have issues of child labor in the value chain, you must understand that and make a decision on whether or not you would like to go into that transaction. And if you do, what are the immediate things that you need to make post-integration, or you need to carry out post-integration to make sure that you not assume or take over that responsibility of the target. Second, with respect to investigations, whether those are internal or external with authorities, making sure that you drive the process of such an investigation and you defend the interests of the company. You have probably heard about the recent example of Vale, and Daniel has been involved into that matter. The SEC charging the mining company Vale because of fraudulent and misleading disclosure regarding ESG in connection with the dam of Brumadinho. So that is very relevant work for lawyers. And finally, of course, representing the interest of a company in a dispute, whether litigation or arbitration. Rupert, you were mentioning the case of an acquirer that found out after the integration that the target company did not abide or fail to disclose the non-compliance of health and safety standards with respect to earplugs, and that resulted in liability. So litigation would help you allocate the responsibility of target and acquirer. So for me, those are the 4 things that lawyers should take care on with respect to ESG.
Okay, let me quickly jump to another question. It says, does the German Due Diligence Act require termination of business relationships, and what are the reporting obligations? Philipp?
Good questions. Thank you, Rupert. So termination actually of a business relationship, that would be really an ultima ratio. So kind of a last resort, but still in situations where you're facing a very serious violation of human rights or the environment, where you've kind of tried to work on implementing and developing a process, a concept actually to remedy the risk you are facing, but still the process doesn't work. So you're not able actually to mitigate the risk, and there's no less severe means that you actually have then you might be at a point actually, and you have no chance, let's say, to increase influence over a supplier that might actually lead to remediation of this risk. Then ultima ratio, last resort, you might even be required to terminate the business relationship, but that's specifically stated also as last resort.
Mm-hmm. And do you want to say something about the reporting obligations?
Sure. So usually you always have to provide also an annual report on the fulfillment of your due diligence obligations. And this annual report refers then back to the last financial year and has to be prepared, provided, and made public within 4 months after the end of the financial year.
Mm-hmm. Let me ask a follow-up question to you, Philipp, with regards from a Mexican perspective. Do we have an obligation as a Mexican company to report something?
Well, that depends, of course, on the individual case in question. But you mentioned it before, you as a Mexican company can, for example, be affected in a way because you are a supplier of a German company that's actually then covered by the scope of the Due Diligence Act, and then the German company would have this reporting obligations in that scenario. But the Mexican company for itself would be covered, let's say, indirectly.
So the Mexican company would need to report to the German customer if required, in order to be information to be included in the reporting of the German company. So that's
exactly that's how it would usually work. The German company, because of the due diligence obligation it has, would be pretty selective and would, of course, even more if there's some indication there might be risk involved, will need to be informed as part of their own risk management, risk analysis process, and you will then provide report rather to the German company that has then to report.
Thank you. Another question which I see here in our app, and which we have heard very often in the past, is if my company has not yet started the ESG journey, what should you recommend as a first step? No, I think this is a very common question, Pablo.
So it really depends on where you are in the process, but I would say first, make sure that you have the right people involved in the conversation, both internal and external, because those folks are going to help you identify, assess, manage, monitor, and eventually report on the issues that you uncover. Make sure that you integrate this process into your ERM system or your enterprise risk management system. So first, having the right people. Second, you need to carry out what is called the materiality assessment. That exercise, which involves doing some research, but also tapping into your stakeholders, would allow you to really identify what are the material risks. So ESG should be focused on material risks and opportunities, not every single opportunity or every single risk connected to your operations. And I would say that third and last but not least, make sure that you involve your legal team to map your ESG obligations and commitments. And of course, this can be tricky, and it's a very wholesome task, because it's not only about the black letter law, but also what are the precedents that apply to your business, what are the industry standards depending on your industry, what are the best practices, because eventually and more likely than not, those would become part of the regulation. And also, we have mentioned this before, what are your voluntary commitments, right? If you have committed to net zero emissions, for example, to a certain date, make sure that you track that obligation, because that commitment, because you could be held accountable for that commitment. If you claim that you are using 100% recycled plastic, and you're not, or one of your suppliers is not, you may be liable. And also, very importantly, and I think it's critical to this conversation, you have to understand what are the local implications of your operation and what could be those that are imported, meaning that really originate outside of Mexico, but nonetheless being a subsidiary of an international company, in this case German, or being part of a value chain that touches upon the legislation of other country, you might be subject to a different standard. So this judgment is also critically relevant. Thank you, Rupert.
Okay, thank you. I think it's 11:15 here in Mexico. It's already 6:15 in Germany. Thank you all the participants. I think it was a very interesting chat we had. I hope you can take away some useful information for you and your business. Let me repeat to you, if you have not started yet to look into this issue, now it's the time. I think this is the most important message. Thank you all for your participation. And I understand, Anne-Catherine, Irina, I don't know if someone wants to give some final words from CAMEXA side. I understand that this session has been recorded and it will be available on the CAMEXA homepage, and we also will you will also find the presentation on the homepage of CAMEXA. Thank you very much.
Exactly. Thank you very much, Rupert, and to our experts, HENGELER MUELLER, and our partner or member from WOBESER Sierra, for sharing your knowledge and expertise. And thank you for the audience, and have a very nice midweek.